right. I think we're on part 4 now of the Whitefish Bay, let's say, race discrimination, First Amendment assault, denial of due process saga here. We are talking about the complaint that has been filed against Whitefish Bay now. I think it's a week old. It's made national news, as far as I understand. Certainly the Journal-Sentinel here locally picked it up. And I think it's very interesting for a lot of different reasons. I just want to, for sake of compare and contrast, which is a joke that we often have on this channel. I was at the Renaissance Fair there in Bristol, Wisconsin, the other day, and it just is fascinating to me how inclusive of a spot that is. I mean, if those of you don't know, it's a sort of pseudo Renaissance medieval fair with all the sort of general fairness of, overpriced everything and everything costs something and spectacles and whatnot. But it's also a place for people to display their costumery. And it was fascinating how you could come as Freddy Krueger if you wanted to, and that was okay. And it was also fascinating how we could call it inclusivity, we could call it judgment free. One of those two things was going on there. Yet it was also a fashion show. So I think those two things in my mind are is somewhat contradictory, and maybe I need to work that out there. But that's sort of the place that I'm coming from on that one. So if you don't recall, we are going to go through here when we're at discrimination complaint and the appeals process. So things at Whitefish Bay, I think a commenter put it pretty well. This is, a normal, disagreement, tiff, argument between children, and that the adults, the administration blew it all out of proportion. And now we're going to see the school board and very possibly their attorneys try to put the lid back on everything. So we'll see how that works out for everybody. Discrimination, complaint, and appeals process. We're on paragraph 199, page 25. That's pretty good. We didn't want that. On October 3rd, Ms. White filed a letter with the District Director of Pupil Services, Tim Lemke, which comprised 1, a complaint of racial discrimination against Levick, 2, an appeal of KK's suspension, and 3, a complaint that RL and CL had bullied and harassed KK during the parade. All right. KK returned to school on October 5th. So far, we're doing, somewhat of a balancing act here. Is the threat against the mother, and if you do recall, Amy Levick, the principal, ordered the police, who then threatened the mother if she will. This is Miss White. If she goes to the homecoming event and protests on the other side of the street, she'll be arrested. No, I think it maybe set foot on district property or something like that. She would be arrested. And again, they knew the whole point of her activity was to exercise her First Amendment rights. So they also, I think we're going to compare them saying it's seeming like an admission from Henningsen, and again, we're taking everything the complaint is true, that she didn't really have the grounds to suspend him for 3 days. And they say something like, even if he wasn't, bullying or fighting, we still could get him for the comments that he made outside of school. And so then we're comparing when he made a complaint against another pupil, how they told him they couldn't do anything about it because it was off of school, and now they're saying they can get him when a white person is making a complaint against him on school, off of school grounds. So I think that's the comparison there. That morning, the district held a re-entry meeting with KK. Miss White, KK's stepfather, KK's counsel, Miss Lemke, Miss Levick, and district's counsel, Chrissy Hamill. There she is. She's of a Tolley's law firm. And you will, active viewers of this channel will know her as the attorney for the Germantown School District. I believe she was wearing yellow. Not that that matters, but it's an easy way to identify someone yellow. Even, there's a reason why flowers choose yellow. Let's put it that way. Okay. KK's attorney pointed out, during the during the re-entry meeting. What the heck? Did anybody out there tell me that they've ever experienced a re-entry meeting? I mean, you get suspended and then you come back. You don't have a briefing about it. Levick and Lemke instructed KK not. That's an admission of good doing. Levick and Lemke instructed KK not to talk about the incident or the suspension with other students. Okay, we've been having this one, and tell me if I'm wrong, but Whitefish Bay may want to think about renaming itself from the Whitefish Bay School District to the Whitefish Bay Administer Employment District, because that, again, serves absolutely no didactic purpose whatsoever. What can the other students learn from the suspension, and what can the child learn from the suspension if the child is not allowed to talk about it? Pupil, sorry, big difference. KK's attorney pointed out that such a restriction would violate KK's First Amendment rights. Levick and Lemke's still there, by the way, backed out away from the directive. They still did it. They still said it. It still chills some free speech, in my opinion. Even just telling him, see, now they're like, wow, we don't like it, but now you know that they don't like it. We got some issues. All right, Miss White filed an open records request for the Whitefish Bay Police Department seeking records of the police investigation into RL's allegations against KK. Another really good pro tip. So far, these guys are checking off all the boxes. Wow. Good for them. All right. The police department produced several body cam videos showing police interviews with RL and CL that happened on the evening of the 29th, and another interview with RL's friend O, last name unknown, which occurred on the morning of the 30th. Well, that explains very much why we don't have, I think, more video of what's going on here, that we just had that little snippet there because, let's put it this way. Let's just say there was no rules at all. I wouldn't put out any pupil. I wouldn't put out any body cam footage of minors out there. They may get out there in the course of necessary, things, but I would do my best to keep that from happening. Both CL and RL alleged in their interviews that KK instigated the altercation by making a comment to one of them. And I'm sorry, I said minors, and I really mean pupils. And that's one of the reasons there are pupil records laws, which I think are important. But why I think they're important is because kids don't have any choice about going to the schools, whether they're minors or not minors. They're there as part of the fact that we're making them be there. And so I think for that reason, they shouldn't have to opt in or out of having their information, their otherwise public records be public. However, CL alleged that KK made a comment to RL, while RL alleged that KK made a comment to CL, okay? Neither CL nor RL could remember what specifically KK had said purportedly to start the conversation, okay? For his part, O claimed to have witnessed the altercation, but stated he did not know how the altercation started. So that's weird. Just because, again, if you don't remember from other videos, Amy Levick also interviewed RL, CL, and O. So I'm not clear how O is getting involved with both the police and them. But whatever. That's got it. RL, CL, and O also gave conflicting versions of the alleged shooting comment, which calls their credibility into question. I would leave that last, that calls their credibility into question, out. CL stated that KK was about to fight, but then made the shooting comment, which prompted RL and CL to walk away. In contrast, RL stated that KK was already walking away as he made the comment. O stated that KK made the comment and then continued to engage with CL and RL and made additional comments to them. Okay, here's where I'm at. The which calls their credibility into question, I would just leave that part out, either just because it violates the show it, don't say it rule, and also because, I think that's more of a legal determination. And though, if Levick or the police or whatever had acted like that it did call their credibility in question, or refused to take that into account, that is something that you may want to put in there. But to say that you, as the reader, it should call their credibility into question as like a fact, that I think is not best policy. The recordings also show RL admitting to the police that he pushed KK, that he was bigger and stronger than KK, and that he verbally insulted KK with the goal of humiliating him, all of which corroborates Miss White's claim that RL and CL harassed and bullied KK during the homecoming queen. I think it's a little unclear, but from what I'm getting from that, they're admitting that there was an altercation. They're disputing who started it. If Miss White and KK had the opportunity to confront RL and CL and O, or review their statements before Levick and Huntington issued the suspension, they could have challenged the credibility of their allegations and prevented the district from entering a damaging falsehood in KK's discipline record. I don't know that you get the necessarily... I'm going to guess that Elizabeth Lambert knows more about this than I do, but I'm saying the opportunity to confront, I don't necessarily know that goes in with a suspension, but I'm totally willing to learn. The police records also included body cam footage of the conversation between Levick and Sergeant Rossman described in the earlier paragraphs, in which Miss Levick falsely implied that Miss White had previously made a gun threat and expressed animus against KK and Miss White based on their neighborhood and family. I think the gun threat in there and the implication, I get that. Here's the point that I want to make on that thing. I think that the implication is magnified. That's why I'm sort of making this face here. Is magnified out of what it would be because of who it's to. I think something that might be, let's say when you're, making implications to police, you're playing with fire, and I think people know that. Excuse me. On October 13th, Miss White counsel emailed district counsel and indicated that Miss White had obtained additional evidence that she wished to submit in support of the discrimination complaint and suspension appeal she had filed on October 3rd. I also don't get why they're immediately suspending him from school for... Yeah, that whole suspension thing just seemed like a bad move. I'd like to hear the defense of that a little bit more clearly if they make one. On October 18th, Miss White's counsel provided the police video to district counsel by uploading the videos to shared Google folder. I mean, we assume that they are talking with the police and district administrators just on the video. And I'm assuming, here's the problem with, I guess, we know that John Thompson, the district administrator, is basically part of this decision from the allegations with Levick. So showing, I mean, I see why, but I'm it's a good paper trail, but I just want people to understand that, if you were doing this and this was your kid and you were the one sending them the stuff, you probably need to assume that this principal is not making this level of a decision without checking with a superintendent, especially at a district of this size. 4,000 pupils. I'm sorry, I should know that. One high school, one middle school, 2 elementary schools. Okay. Now, we should just know that so when you send the evidence of the principal doing something wrong to the administrator, they're going to be defensive, to say the least. But that's how it goes. I'm just trying to keep that in everybody's mind, that if it's just like asking the Equal Rights Division supervisor to help with the decisions, to help review the decisions of the ALJs, because she's assisting them in making those decisions, that, she may be a little defensive. Okay. On October 3rd, fantastic date, Ms. White and KK's counsel sent a letter to defendants explaining how the police video revealed credibility issues with RLCL and O's allegations. It's just a revealed credibility issues. I mean, I could see raised them, issues of credibility. It's just the revealed as if that's a fact. I think it's not necessarily a fact until it's a fact. Ms. White further agreed to extend the deadline for Mr. Lemke to render a decision on the discrimination complaint, and they have these fake deadlines, and appealed by several days to allow Mr. Lemke time to review the additional video evidence. How nice of everybody. On November 13th, Mr. Lemke doesn't do what Mr. Thompson wants. He's out. And he's, if not participating in the decision with Levick, sees her as more than a peer. So, let's be clear about that. And besides which, it's not clear to what point the attorney's getting involved here, but my guess is that the attorney, Chrissy Hamill, is basically writing all these decisions. Lemke issued a decision upholding KK's suspension. All right. Finding that Levick and Henningsen did not discriminate against KK on the basis of race. Okay. Lemke did not include the police body cam evidence Ms. White had provided in the list of evidence he considered in rendering this decision. Well, that's weird. Further, Lemke determined that Levick and Henningsen had not discriminated against KK based only on a McDonnell-Douglas discrimination analysis? What the hell is that? He did not consider any other applicable ways of establishing a discrimination claim. Okay, McDonnell-Douglas is simply this. If you don't have a direct evidence of discrimination, which we have direct evidence of discrimination here, those people who live on shoreland is direct evidence of discrimination. The fact that he doesn't say blacks doesn't matter here, okay? So just first of all, McDonnell-Douglas is out the door because that's only for an indirect proof method, okay? If you need to prove discrimination based on statistical references or whatever, then you prove that you're qualified, that you're black, for example, and that you were terminated. And then there are other people who were not black, were also qualified, who were not terminated, okay? That's, or thrown out of the building and terminated because it was supposedly unclean or whatever, okay? That's McDonnell-Douglas. That's the indirect proof method. Now, the second thing, bright red flag for me again, what do I know, is McDonnell-Douglas is an employment law discrimination. It has nothing to do, it's not an analysis of whether, again, that sounds like the attorney. It certainly doesn't sound like Mr. Lemke. Okay, I assume that's what he's talking about. He did not say any other ways of establishing a discrimination complaint. And again, I could be all wrong. McDonnell Douglas could be used all the time in Title IX. I don't know. I mean, in many ways, those things are similar. But again, that's would go back to just that evidence there, okay? Let alone the... Okay. So with that... Sorry. McDonnell Douglas is going to say, okay, you're black. Okay, we suspended you. Okay, we didn't suspend the other people, but you're a jerk. And it's because you're a jerk. And now here's the key thing about that, if everything else applies. Remember, under the McDonnell Douglas framework here, you can be fired for any reason or no reason at all. Well, guess what? You can't be suspended for no reason, any reason or no reason at all. That's a big difference there. So then the proof becomes, in an employment one, you would come back and say, hey, your reason for terminating the guy, the so-called bona fide business reason is false, right? That's the next step. Or you do that I just think that analysis is going to be different there, but okay, we'll move on. Ms. White had also attached her complaint statements from 2 former Whitefish Bay students of color describing incidents where Miss Levick had disciplined them based on allegations by white students without giving them a fair opportunity to contest the allegations, and Mr. Lemke did not consider those statements in rendering his decision. Get that. Miss White appealed Mr. Lemke's decision. They've changed this. We're going to get into that because this is I've got something that's coming up that's all about this section here, but we'll deal with this. Again, in my mind, what's going on is that Lemke's decision is not Lemke's decision. It's really the Atoli's law firm's decision, and that they're also the ones setting the policy and everything else, and sort of this is all a whole sham, which, it's supposed to be a sham. It's just supposed to be a sham run by district administrators, not by attorneys. I think that's the issue there. All right. Under the district's non-discrimination policy, then in effect, an appeal of a discrimination determination was to be directed to the Superintendent Thompson, unless the complainant involved alleged improper behavior by Thompson, which it could have. They may just not have known about it. Aha. Mr. Lemke's written decision indicated that Thompson had played an active role in some of the actions that gave rise to the complaint, including the decision to exclude KK from homecoming activities. Yeah, that was probably shouldn't have put that in writing, but okay. And the decision to threaten SW with arrest. So they know all about it, and they're actively defending a decision to threaten SW with arrest after she told the officer of her intent to protest. So now... not only have they threatened this lady and abused her First Amendment rights, but they're defending in writing, with apparently the aid of an attorney, their decision to violate her First Amendment rights. How awesome for everybody. But at least the big outcome here of they're giving her the due process rights is they're explaining to us why it's okay for them to violate her First Amendment rights. Okay. And again, I have reported to you firsthand that I was at one of these meetings, and Mr. Thompson, said in closing that these are tough issues here. But I disagree with him. I don't think these are tough issues. I don't think it takes any effort at all. I don't think it's difficult not to send the police to people's houses and threaten them for exercising their First Amendment rights. I don't think that's difficult. I think it's quite easy to not do that. Miss White therefore requested, pursuant to district policy, that the school board and not Thompson hear her appeal. The school board declined Miss White's request and instructed her to present her appeal to Miss Thompson. Now, the school board has entered, and I can remind everybody that the head of the school board at this time was Ann Kearney. The names must be named, okay? That is the wife of the current dean of the Marquette Law School. She's my neighbor, lives on my block there. She's my former law school professor. I have a high regard for her in most every respect, but the management, the direction the school board took while this happened was not acceptable. She's also a very noted appeal attorney and has successfully, let's say, overturned many criminal convictions. Uh, there's good and bad in all things, as we say, as I say anyway. On December 11th, 2023, Ms. White's counsel sent to Dr. Thompson an email with a link to a Google folder containing evidence supportive of the allegations in the complaint, as well as several U.S. Department of Education Office for Civil Rights cases discussing the kinds of evidence that can be used to prove racial discrimination in the school context. Ms. White and counsel then met with Dr. Thompson and discussed at length the legal guidance and evidence included in the folder. Just so you know, I'm assuming that when they say Miss White and counsel, they're meaning Miss White and undersigned counsel, meaning I assume Elizabeth Lambert. But I don't know. Let's say there is a general practice out there, especially with attorneys, to sort of deliberately cloud that subject for all sorts of reasons. But that's why. But we're just going to assume that that's what we're talking about. Okay. Then met with Dr. Thompson and discussed at length the legal guidance and evidence included in the folder. During the December, this is I just want to take a brief pause, and I know we've had a lot of those here, but as a pro tip in terms of parental advocacy, you want to have these. If you have an attorney, one of your goals is going to be having a meeting with the superintendent and your attorney and you. And that is going to be, even if they're like, we hate you, and they come out of that meeting seemingly more entrenched than they did before, you will have learned a lot more about what it is and why it is that they're making the decisions. And that knowledge about why they're making the decisions may enable you to move forward with all sorts of either plans, your life, all sorts of things that you would not have been able to do absent that meeting. So I think that's because the frustration of the cloak of these kind of decisions, who's making these decisions here, again, without this suspension process, appeal process, they would not have known that Thompson was intimately involved in all these decisions. Again, Thompson pushing Levick out there, who pushed Henningsen out there, that wouldn't have been known. So again, that's why this is, I think, a big win. And also because the parent here again, Miss White, is able to look the superintendent directly in the eye and tell them as a parent what's up with that. And many of these superintendents aren't, cold reptilian lizards. So it sometimes has an effect. Indicated to, and we are playing averages after all, Dr. Thompson, that she had not received any response to the harassment complaint form she had submitted on September 30th regarding RL and CL's conduct during the homecoming parade, or the sexual harassment complaint she had filed against MS on or around November 2nd. At the end of the meeting, Dr. Thompson stated that he had tremendous faith in his team members, meaning Levick and Henningsen, despite the fact that Miss White and her counsel had just provided him extensive evidence of Levick and Henningsen's biased and unprofessional conduct and failures to follow policy. Again, I think that sort of assumes facts, not in evidence there. 2 days later, assumes accusations. How about that? 2 days later, on December 13th, Assistant Principal Henningsen emailed Miss White an administrative determination, similarly dismissing the 2 harassment complaints. I'm sorry, we're going to back up, but that's good to keep in mind. We're just going to read it 2 different ways. At the end of the meeting, Thompson stated that he had tremendous faith in his team members, meaning Levick and Henningsen, period. Okay? After everything we just read, do we need to know more? Okay? Then, again, I think we just leave it out. Ms. Henningsen's determination of the harassment complaints were untimely under state law and district policy. Oh, my. Whitefish Bay. Oh my, it was too difficult. Ooh, sounds very difficult. Henningsen dismissed the complaint against RL and CL on grounds that the altercation constituted conflict, but not bullying. Okay, despite ample evidence, including RL's own admission that RL insulted and physically aggressed against KK, yada, 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 okay? I would just say despite the evidence, but we can keep going. Henningsen dismissed the sexual harassment complaint against MS on the grounds that the complaint alleged a single time that MS was on high school grounds to bother KK and the behavior was not chronic, completely ignoring the many other times known to her that MS's harassment affected KK on school grounds, including when she followed KK and MR making threatening gestures at the football game and when she sent messages to MR that disrupted KK's ability to maintain his friendship with MR at school. And when she sent text messages to KK and posted a video of KK that caused him such distress that he could not focus in class and on at least one occasion needed to be picked up and brought home. Yeah, we read through all those. Those didn't seem like nothing. On December 15th, Dr. Thompson issued a determination. Ooh, I love these footnotes. It's just hard to scroll down to. It's attached. A determination as to Miss White's appeal from Mr. Lemke's, a determination of the discrimination complaint at suspension appeal Miss White had filed on October. I like the way we say like stage 1 grievance, stage 2, step 1, step 2, because that's really all that's going on. Let's not really think that this is Thompson again, based on my knowledge and understanding, all of these decisions are being made ultimately by Chrissy Hamill, the attorney, and then the administrators are basically just taking her advice. I don't know that to be true. That's what I believe to be true based on my experience. Okay. On December 15th, Dr. Thompson issued a determination, yada, yada, yada. Dr. Thompson's determination explicitly declined to consider the evidence Miss White had presented on the December 11th meeting with respect to the racially discriminatory nature of Miss Lovick and Miss Henningsen's comment. Well, why would he do that? Did he say why? That's troubling. On December 21st, Miss White appealed Miss Henningsen's administrative determination regarding 2 harassment complaints to Dr. Thompson. On January 4th of 2024, Dr. Thompson met with Miss White and KK regarding their appeal of Henningsen's determination to harassment complaints. During the January 4th meeting, okay, so this time he's meeting with the mom and the kid without the parent. Thompson spoke with KK about messages KK had exchanged with MS in September. As Dr. Thompson acknowledged KK's participation involved asking MS to stop bothering him and MR. Dr. Thompson's exact words during the meeting were, "In those exchanges, I noticed you saying stop this, right? I don't want to be a part of this." Dr. Thompson also told KK he admired how KK told MS to leave him alone. They must teach that at administrator college to say admired. That was not sure that behavior from MS is going to change. Okay. However, on January 2nd, so he gave him some hope, but then in their written decision, upholding Henningsen's dismissal of the 2 harassment complaints, okay, he still upheld the decision. Completely inverting his I won't say completely, but inverting his acknowledgement during the meeting that KK's role in the text exchanges was to ask MS to stop her misconduct. Dr. Thompson's January 12th decision portrays KK and MS as equally culpable participants in an angry, bitter, and profane exchanges, and includes no acknowledgement that KK's role in the exchange was repeatedly to ask MS to stop bothering him and to move on. And because this is becoming here, what's happening is childish drama, adults get involved, commit race and discrimination and First Amendment retaliation. And now this is the cover-up here. Because, and the problem here, and I have this happen all the time, is when the government, when people come to me, a lot of the big problem, and we've talked about this on the channel, is when the government lies. It's one of the worst things about you. It's one of the worst things that can happen to you, even though it seems like it would be the easiest thing to shrug off. Okay? And here, it's got to be driving these people crazy that the superintendent is saying that these text messages are equally bad, when everybody knows they're not, including the superintendent. He's just saying that to cover up for his team, who failed and refused to investigate, including Amy Levick. This is what we call problematic. All right. And here we go. On January 19th, Ms. White appealed the determinations of the discrimination complaint, the suspension appeal, and the 2 harassment appeals to the school board. Okay, so now we finally moved through the administration. We're at the school board right here. We're going to see what the school board is going to take this thing and how they're going to run with it. We'll see what happens. Here, I think, again, in my mind, just to wrap this one up, I think the keyest thing to know is, assuming everything is true here, John Thompson, the administrator, the district administrator, the superintendent, is basically putting in writing something that he knows is not true to back up his team, and it's damaging a pupil. Okay, so again, if this is just, let's do our test here. If this was a school district, you would assume and demand that decisions were being made in favor of the pupils. Okay, so you would expect there to be a benefit to the pupil in the determination, and not just that pupil, but all the pupils. Because again, the point of discipline is not just to teach that pupil, it's to teach everybody. And the purpose of that is also to create order for everybody, and so in a learning environment for everybody. That's all legitimate things, right? But no, the government power here is being used to cover up for district administrators. So that's why we say, is this really, shouldn't we then transform the name of this school district from the Whitefish Bay School District to, in fact, the Whitefish Bay Administer Employment District, because it seems to me that that's what the government power of the village of Whitefish Bay is being used here for, is to protect district administrators and their high-ranking employees. And I think that needs to end. So stick with us. We'll keep you informed.